everybody, welcome to iExamBee's LegalBee. This is Amrita, your law faculty here at iExamBee. In this video today, I'm going to discuss with you all the latest landmark judgments from 16th of June to 30th of June 2023. ये सीरीज एक्सक्लूसिवली लीगल बी पे हमने स्टार्ट की है एंड दिस वी कंटिन्यू एवरी 15 days. If you have missed out the rest of the videos, do check it out in the playlist of our channel Legal Bee. Every 15 days, we try to bring up latest landmark judgments in which various law points have been discussed by the Honorable Supreme Court, and also of some high courts. I try to bring some judgments in front of you through this video. इस वीडियो के साथ जो पीपीटी है आप उसे डाउनलोड कर सकते हैं एंड यू कैन ऑल्सो कीप अ प्रिंट आउट ऑफ ऑल द पीपीटीज एवरी 15 days. द जजमेंट्स दैट आर बीइंग कंसोलिडेटेड यू कैन कंसोलिडेट इट फॉर योर रेफरेंस एंड दिस कैन बी वेरी हेल्पफुल फॉर यू अगर आप कोई जुडिशरी का एग्जामिनेशन के लिए प्रिपेयर कर रहे हैं या फिर आप कोई भी एग्जाम के लिए प्रिपेयर कर रहे हैं जिसमें लेटेस्ट जजमेंट्स आपको पढ़ने ज़रूरी होते हैं, कोई इंटरव्यू के लिए जा रहे हैं, or else if you are practicing in the courts, you need to be updated with the latest landmark judgments, the law points that are being discussed. So ये सारे points आपके लिए एक काफ़ी अच्छा ready reference बन सकते हैं in this particular video. So don't forget to subscribe to LegalBee. If you have any queries also, you can write to us on hello@iexambee.com. Call on this number 9205524028. Visit our website www.iexambee.com and also check out all the courses that are available at iExamBee. Latest landmark judgments, June 16th to 30th, I will be discussing in this particular video today. Supreme Court is on vacation, but जो vacation bench के कुछ landmark judgments है वो मैं आपके साथ discuss करूँगी and उसके साथ ही I will be discussing some judgments of the High Courts also. First is Bank of Baroda and others versus Baljeet Singh. This is a judgment by the Honorable Supreme Court of India and this is relating to an appeal that was arising out of judgment and order passed by the High Court of Punjab and Haryana. इस particular case में क्या हुआ था? The High Court's judgment, actually High Court had set aside the judgment of the appellate court as well as the trial court. It's a civil case and it's against an appointment that has been made. The Bank of Baroda में एक appointment हुआ था and that appointment was done out of we can say it was an appointment that was done out of compassion. Compassionate appointment term यूज किया गया है यहाँ पे. So इस compassionate appointment को challenge किया गया and ultimately High Court did not actually understand that compassionate appointments are not something which are a part of the policy. तो ये Supreme Court ने High Court के judgment को actually यहाँ पर set aside किया है and जो appellant है बैंक उसके अपील भी अलाउ किया है यहाँ पे and appeal is allowed over here in this particular case. The case law that has been referred by Supreme Court in this particular case जो basically precedent यहाँ पे refer किया गया है Indian Bank versus Promila 2020. उसमें क्या observe किया था that it has been observed that eligibility for compassionate appointment must be as per the applicable scheme and the courts cannot substitute a scheme or add or substitute from the terms thereof, exercising judicial review. Whatever terms and policies are there, that cannot be amended and something cannot be done out of compassion. So the court has actually allowed this particular appeal and restored and has set aside the judgment of the High Court, which was actually not right. The relief that was sought by the respondent in the suit was basically relating to injunction. इसलिए ये एक civil case है. Mandatory injunction seek किया गया था against the appointment in appellant bank because compassionate basis पे अगर आप appointment grant कर रहे हो then that is not permissible. So उसको challenge किया गया था but court ने क्या कहा है that ultimately इस precedent को rely किया गया है and the law point that is important here is that eligibility on the basis of compassionate appointment is not applicable. You have to go as per the terms and conditions of the policy of the bank and the appointment service rules. तो ये सारी चीज़ें इसमें डिस्कस की गई हैं. अगर आप इस जजमेंट को डिटेल में पढ़ लेते हैं तो आपको और आइडिया लग जाएगा बेसिक फैक्ट्स के बारे में. I will be sticking only to the crisp law points basically. ये एक और एक केस लॉ है स्टेट ऑफ पंजाब वर्सेस केवल कृष्ण एंड इसमें ऑनरेबल सुप्रीम कोर्ट ने क्या किया है अपील हैज़ बीन फाइल्ड अगेंस्ट जजमेंट एंड ऑर्डर अगेन ऑफ हाई कोर्ट ऑफ पंजाब एंड हरियाणा and the judgment of trial court which was regarding conviction and sentencing the respondent under section 302 of IPC. So Supreme Court has upheld the order of acquittal which was granted by the High Court. Actually High Court ने conviction को reverse करके acquittal दे दिया था. So Supreme Court ने High Court के order को uphold किया है. The reason for acquittal was basically that the case is based on circumstantial evidence. Circumstantial evidence पे अगर case है, so it should be crystal clear, and always remember this very important point from Evidence Act basically कि circumstantial evidence अगर है, so one chain and the chain should be complete basically. Every part of the chain should be linked with each other and there shouldn't be any loophole. Because अगर आप circumstantial evidence पर किसी को conviction दे रहे हो, it's a good evidence, but again the chain should not break. And इस particular case में जो circumstances थे, the case was not proved beyond reasonable doubt, and the circumstances of last seen theory भी बहुत important होती है क्रिमिनल लॉ में, एंड ये अक्यूज्ड के फेवर में चली जाती है अगर वो सफिशिएंटली प्रूव नहीं होता है तो. सो इन दिस केस इट वाज आल्सो इनकंक्लूसिव. सो सेक्शन 106 ऑफ एविडेंस एक्ट बेसिकली जो यहाँ पर बर्डन है, प्रूविंग का बर्डन, वो प्रोसिक्यूशन से अक्यूज पर शिफ्ट नहीं हो पा रहा है इस पर्टिकुलर केस में. दिस वाज डिस्कस्ड बाय द सुप्रीम कोर्ट. सो इफ इट इज नॉट बीइंग एबल टू शिफ्ट, देयर इज नो ओकेजन टू प्लेस द बर्डन ऑन द अक्यूज्ड, then we cannot grant conviction. We will always incline towards granting acquittal. ये point यहाँ पर discuss किया गया है, and this is very important law point actually. Criminal law में बहुत ही important point है ये. Next case, Davinder Singh versus State of Punjab. Honorable Supreme Court has in this case, this is actually facts are relating to 376 of IPC, 452 and 506. And the appellant, he was convicted for of these offences. Then he went to the High Court of Punjab and Haryana. And इसमें again High Court of Punjab and Haryana के decision के against appeal file की गई है in the Supreme Court. The Supreme Court has set aside the judgment and order of High Court and has granted acquittal to the accused appellants. Again, there were certain observations that the court has made over here, that appellant along with other co-accused persons had gone to the residence of uncle of the prosecutrix, where she was temporarily staying, and it is true that if a material witness who would unfold the genesis of the incident or an essential part of the prosecution case is not convincingly brought to fore otherwise, there is a gap or infirmity in the prosecution case. Basically यहाँ पे प्रोसिक्यूशन विटनेस में एक बहुत ही इंपॉर्टेंट विटनेस जो उसके अंकल है उसे नहीं बुलाया गया था. सो दिस इज समथिंग विच विल गो इन फेवर ऑफ द अक्यूज्ड. दिस इज द इम्पॉर्टेंट लूप होल इन प्रोसिक्यूशन एविडेंस विच कोर्ट हैज कंसिडर्ड हियर, एंड दिस इज डेफिशिएंसी in the material witnesses if they are not brought to court. So doubt किसके फेवर में जाएगा? accused के फेवर में जाएगा and prosecution के against जाएगा. That the material witness is not brought to the court because it is possible that the material witness, if goes against the prosecution, the entire case will be unturned. So this is something which the court will be presuming in favor of the accused. ये इस पर्टिकुलर केस में डिस्कस किया गया है. मैं रेकमेंड करूंगी इस केस को तो आप बहुत ही अच्छे से फैक्ट्स को डिटेल में पढ़िए, एंड ये लॉ पॉइंट फिर अगर आप वापस ये वीडियो सुने या फिर आपको समझ में अगर आ गया होगा, आप इसको वापस बहुत अच्छे से लिंक कर पाएंगे अगर आप फैक्ट्स देख लेते हैं तो. ड्यू टू पॉसिटी ऑफ टाइम आई वोंट बी एबल टू डिस्कस ईच एंड एवरी केस इन वेरी मच डिटेल, बट दिस इज ऑल्सो वेरी इंपॉर्टेंट. जजमेंट. स्टेट ऑफ गुजरात वर्सेस अंगू भाई, रणछोड़ भाई, Baria and one other. This is a case by the Gujarat High Court. In this case, an appeal had been filed against the judgment in order of trial court of Jamnagar in Gujarat, and this was basically acquitting the accused under section 7, 12, 13, 1D, 13, 2 of the Prevention and Corruption Act. The High Court has confirmed the decision of trial court and held as follows. What the court has held that we will be going into. पहले आपको ये तो समझ में आ गया होगा that acquittal का order हुआ था and High Court ने ये decision को confirm किया है. Means trial court के decision को High Court ने confirm तो किया है. So what is the law point that has to be discussed over here is, it is a settled position of law that the powers going to be exercised by High Court in an appeal against the order of acquittal is that the High Court can go into the reviewing of evidence over here. But if it is an acquittal, it will not interfere with an order of acquittal, because with the passing of an order of acquittal, the presumption of innocence in favor of the accused is reinforced. So presumption of innocence, वैसे तो presumption है ही, and it is getting reinforced when there is acquittal order in favor of the accused. Are you understanding the thing that is being said over here? That अगर आपको acquittal को reverse करना है, it is not that easy. Remember, when the court, this Supreme Court has held in the case of Allah Rakha K Mansoori versus State of Gujarat also, if there are two views that are possible, the view which favors the accused has to be adopted. पहले तो presumption of innocence एक universal principle है ही, and अगर acquittal उसके favor में मिल जाता है, then again that will be reinforced, means there is an additional advantage to the accused over here. So here the court has not interfered in the particular case. Next judgment is from Manipur High Court, Mohammad Nurul Huda versus Home Commissioner, Home Government, basically the Home Department of Manipur and others. This is also a very nice case, means the facts are also good and the law point is also good in this case. I also would recommend you all to go into the details of this case as well. In this case, under Article 226 of the Constitution, the detainee has challenged his detention order. Detainee का मतलब आप सबको पता होगा, a person who has been detained under preventive detention laws. So there is a person who is a petitioner here. He had been detained by the orders of the Special Home Secretary Government of Manipur under Section 3 of Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. So what was the question, the point of determination over here, that whether that order, at least 3 months detention order has been granted by Article 22(4) of the Constitution. Article 22 protects the rights of the accused and also of the detainees to some extent. Detainees थोड़ा exception category में आते हैं, ये भी आप अच्छे से पढ़ लीजिए. So considering that till 3 months it is allowed, if there is an unexplained delay in disposal of representation which the detainee has made as provided under Article 222 clause 5 of the Constitution, then in that case what can be done? So here court has taken reference of Apex Court's judgment, Pramod Singla versus Union of India, and in that it was held every procedural rigidity must be followed in entirety by the government in cases of preventive detention, and every lapse in the procedure must give rise to a benefit in the case of detainee. यानी कि अगर procedural lapse है तो उसका benefit detainee को जाएगा. This is also a very important law point. So in cases of preventive detention, the courts are conferred with the duty that has been given the utmost importance by Constitution. Courts are having duty over here. That is Article 22 provides it. So यहाँ पर Article 22 and 21 भी picture में आ जाता है. So from this decision, from relying on this decision and the principle of presumption in favor of the detainee if he is in custody, and there are some procedural lapse on parts of the on parts of the government, then that is something which will go in favor of the detainee. So he was actually released in this particular case by the order of High Court. Another judgment is Hemant Dheerajlal Bankar and others versus State of Maharashtra and others. This is a judgment by the Bombay High Court, recent one, 22nd June को आया है ये judgment, and this is relating to Maharashtra Control of Organized Crime Act, Section 3, MOCA Act basically. So इसमें क्या हुआ है, basically quashing of FIR and quashing of proceedings that have been initiated against accused appellants. They have accused applicants. They have filed an application under this that उनके against जो MOCA के और जो FIR register किया गया है उसे quash कर दिया जाए. So basically the law point that has been discussed over here is that if we are talking about Section 3 Clause 2 of the MOCA Act, if it is proved that the accused has rendered any kind of financial assistance also to a person who is already accused or reasonably suspected of an offense of the nature of organized crime. So this is a serious affair. MOCA में अगर organized crime में वो already charged है under Section 3 Clause 2, if that person, other people are financially assisting that person who is charged with that offense or he is involved in that organized crime activity, the other people will also be charged under section 3 clause 2. So this is again a presumption. The court shall presume word has been used over here. So this is a legal presumption against the accused over here. This is very, very important point relating to the MOCA Act that has been discussed in this judgment by Bombay High Court. Ninad Deolkar versus Goa Human Rights Commission and others. This is also very, very recent judgment by the Bombay High Court. This is also an interesting one. Basically here the petitioner is a police officer. He has come against the inquiry that has been made by the Human Rights Commissioner. The Human Rights Commissioner, how did he intervene? He intervened because there was an arbitrary arrest, according to him, of a person who is the accused. He was accused under section 151 of IPC. And he was also accused under section 341. So इस offense के लिए basically उसको arrest की गई थी under 151 of IPC. Actually he was just charged for a trivial matter. He was creating some scene on the road and he was actually obstructing the people from traveling on the road. ऐसा कुछ उसके facts हैं. So basically the arrest that was made here was unnecessary according to the Human Rights Commissioner. So the court, so the police officer has come in as a petitioner before the High Court, and the High Court has also dismissed the petition with cost of rupees 10,000 because the person who was accused, he was actually arrested, and for arrest earlier he was also sent for medical. So medical के लिए जब भेजा गया तब पता चला that he was already having high BP also at the time, and the arrest that was made was unnecessary. So the point that has been discussed in this particular case is relating to the Arnesh Kumar versus State of Bihar judgment. This is very, very landmark judgment. Everybody knows, I think, relating to arbitrary arrests and the procedure that has to be followed. And section 41A of CRPC, if we are talking about, that has laid down a procedure basically. So what court has said over here that the police officer is empowered under section 41 of CRPC to cause arrest in case of cognizable offences. But अगर offence bailable है, if the offence is bailable, then in that case the police officer should tell the accused about the bail, his right to take bail, and release him on bail as well if it is a bailable offence. So these things are something which the police officer is having duty to do it, and arbitrary arrests are something which are not permissible. So Human Rights Commissioner Goa has actually acted within his powers, and his report also has been taken into consideration by the High Court in this particular case, and it has been confirmed, we can say. So this is all that I had to discuss with you all, the recent law points. This video is having many law points that have come up in this particular case, especially relating to writs and constitution and criminal law. Criminal law से काफ़ी law points आए हैं in 15 days में. अगर आप इन judgments को detail में पढ़ते हैं, it will be definitely helping you out in understanding the law and also the applicability of the law provisions in a नाइस मैनर. अगर आप जुडिशरी के लिए भी प्रिपेयर कर रहे हैं, ये सारे जजमेंट्स एंड लॉ पॉइंट्स आपका रिविजन भी होगा, आपको यू विल बी अपडेटेड विद व्हाट द लॉज आर कमिंग एंड हाउ लॉज आर डेवलपिंग विद टाइम. So this you can practice, and again don't forget to subscribe to LegalBee and stay updated with all such kind of beneficial content and videos that we keep on bringing up at LegalBee, and prepare 50% faster with iExamBee for all the examinations. Have a good day, everybody.